Welcome back. Well, let's get more around the situation around our judges and our judiciary. The Chief Justice Mogoeng Mogoeng talking about this today. You heard him say earlier that he had to withstand pressure and that people were attacking the judiciary because they had their own agenda. Also speaking about the fact that judges have simply too many cases to adjudicate. In other words, their caseload is too high. Michelle Roux is an advocate, a law lecturer and co-author of the book Lawfare, Judging Politics in South Africa. Michelle, good evening. Thanks so much for coming in.
Thank you for having me.
Okay, let's start with the issue of attacks on judges. They've come from various quarters. I should probably mention the name of the economic freedom fighters here. There have been various attacks from them on judges. What do you think's driving that?
I think, you know, what the judges and what the courts are doing at the moment in our politics is stepping into some of the gaps. So, in a way, because Parliament isn't doing its job in terms of oversight of the executive, the resort to courts is inevitable. And then when you lose in court or when you disagree with the judgment, it's very easy to then attack judges. And because they are, they are not elected politicians, the questions around who are these people, should they have this much power, that's a healthy debate to have. Where it crosses the line is where it becomes an attack on the individual judge because of their background, because of who they are, or it gets into the politics of the thing rather than merely looking at the judgment and saying, well, does this withstand scrutiny? Is it logical? Was it based on the evidence? Did it ignore things that it should have looked at? A robust debate of high-profile cases is healthy, and that's a good thing. It's when it becomes a personal attack that it potentially starts undermining the integrity of the courts. And that's where their credibility comes from, that we believe that those are fair-minded, reasonable people dispensing justice.
It's a question around legitimacy and have we appointed them in the right way? Do we accept the outcome? The Chief Justice's response today, I mean, in a way, it's quite a strong response. He's actually ascribed a motive to the people who are attacking the judges.
And, obviously the Chief Justice has been very outspoken in defending the judiciary, which obviously we welcome. It's a different tone to what we've seen from other Chief Justices. But certainly when under attack, the fact that, the Judge President of the Gauteng Division came out very strongly as soon as his judges were singled out for attack, and then the next day the Chief Justice, together with other heads of court, met and had a press conference to say, if you know anything about corrupt judges, please tell us. Please tell the JSC. There are structures and processes to hold judges accountable. No one is saying they are not accountable, but they're accountable through a process that the Judicial Services Commission runs. And so to merely take to Twitter or just throw it out there that there are corrupt judges or that these judges are somehow not doing the job that they took an oath to uphold the Constitution and perform their duties, that's a very serious allegation that risks undermining the constitutional project and our democracy. So obviously, if there is evidence of corruption in the judiciary, it must absolutely come out. And that's what the Chief Justice was saying today. The fact that there isn't that evidence so far means that you do wonder why these attacks are coming and what's behind them.
The issue of caseloads, and basically the Chief Justice saying today that judges have too many cases to adjudicate. Is it that there are too many cases, or do we not have enough judges? Do we need to rethink how we do all of this to resolve that problem?
I think it may well be a combination of all of those and probably some other challenges. We must always remember that most of the caseload and most of the work that the judiciary does, and if we include the magistracy in this, the overwhelming majority of cases, the bread and butter cases of most courts, are not the ones where the cameras go and it's live tweeted and reporters attend. It's the very basic, simple dispute resolution and the criminal justice system. And we know the problem there around very practical administration of running the court system. It's not as well resourced as it could be, and those challenges mean that people wait a long time for court dates. There's a backlog to actually get your trial date, and when you, as an advocate, when you look at that trial roll, the overwhelming majority of those cases are road accident fund matters, which settle on the day or are not ready to run. So in fact, a mere handful of cases out of the 100 or 200 that may be set down for that day will actually start running. But it means that other cases that were ready to go couldn't get on the roll for that day. So there's some very practical challenges to the backlog. There certainly are moves that I'm aware of in the Gauteng courts where the judges are trying to manage the case system. So from the moment you go into court, there'll be a judge looking at, okay, you've taken too long to file this evidence, we're still waiting for that from that party, we need to keep an eye on the timetable, and only when the case is really ready to run will you actually get a date on the roll. And that system is certainly yielding results. But the judges have an enormous caseload with very little assistance and some challenging physical circumstances to work in.
I mean, most journalists I know, but I think this reflects a problem in society, is that we will all know of cases. I mean, I speak to people on a regular basis who will have been charged with something. They wait 2 to 3 years before the first witness testimony is heard. What is that? Why is there such a big delay in our system? I mean, certainly in other countries, certainly better resource countries than ours, are able to, you know, if you're accused of murder, you'll be in jail within the first year.
Again, it's you know, the judiciary works in tandem with the other law enforcement agencies. So the police, obviously in certain cases the Hawks, and then obviously the prosecutors, the NPA. And we know the challenges of all of those institutions and organizations at the moment. So quite practically the caseload on investigating officers and on the prosecutors and then on the magistrates and then on the High Court judges, it's a snowball effect. And, you know, a systematic approach to try to improve resourcing and try to identify where the backlogs are coming from, where the bottlenecks are, where we need more resources. That's the exercise that's happening. And now that we have an Office of the Chief Justice that is trying to really make the court system more efficient, there's a renewed attention and focus to it. And so something like the annual report that came out today tells a story of what is practically happening around the country in that system and where resourcing is needed. And certainly modernization is a priority.
Well, part of that is anyone who's been into a courtroom knows it literally kills an entire rainforest to hear one court case. I'm talking about the vast, literally vast amounts of paper. You need to actually have suitcases on wheels to get it all in there. I mean, all of that could fit on one flash drive. How's that digitization process going? Are we able to say in 2 or 3 or 5 years' time we'll actually be able to do a court case without paper?
So we are, unfortunately, lawyers like paper. It's where we can highlight and put flags and have 3 different things open at the same time. And obviously you could do that on screen. But it is you know, we're all wed to the way that we work, which is paper-driven. But certainly in terms of the filing system at court, paper files where, you know, you could have e-filing. You could have a digitized system that deals with the actual case files. That would certainly assist. I mean, I've just had the opportunity to do my first stint as an acting judge, and the very practical challenge of the court file and whether the court file has got everything in it that it needs to have, and that filing system, certainly digitization of all of that would streamline those delays and the postponement that has to happen simply because the case file isn't ready to run.
In the middle of all of this is the Judicial Service Commission, and this is the JSC of the people who appoint judges, chaired by the Chief Justice. They're also discipline judges. We now have a situation where we have political figures. Now, we've always had political figures. We've never in the past, as far as I'm aware, had MPs, and I'm talking specifically around Julius Malema, the leader of the EFF, who's on the Judicial Service Commission, as is his right. And yet he's one of the people who strongly attack judges. He's representing a party that strongly attacked judges. Advocate Dahlia Mpofu, again, as is his right, is on the commission representing, I think it is, advocates. Is that going to pose some problems in the JSC going forward, that we're going to have people who are actors and referees?
I think the mix in the JSC is certainly something that commentators and the profession has been debating since it in fact started. Because you want a mix of political and legal expertise and the judges themselves, and those are the constituencies that are represented in the commission. And you want this dynamic process, but certainly potential conflicts of interest in that room are a challenge. Now, obviously, the judges that are appointed are not appointed to hear a particular case. But what's covered in those interviews has certainly been a subject of much debate and criticism, because we don't see, so if you think, for example, of the confirmation hearings that they have in the United States, where for days and days a candidate sits there and their background and scandal may well be covered, and that's all very interesting, and there will be political point scoring, there always will be. But there's a critical and deep interrogation of your judicial philosophy. What kind of judge are you going to be? What would guide you on the bench? What's the set of values that you bring? And we don't really do that in our JSC interviews. We have moments where we do, but that real interrogation of what is the role of a judge in our society, what is the expectation of them when they're in that job, we don't really interrogate that at the Commission. And so I think the diversity of voices is a good thing that we should embrace, obviously regulating for any dangers. But certainly the richness of the debate in those interviews could be something that needs to be enhanced.
In other words, judges need to answer more questions.
Judges need to answer more questions, and the JSC should articulate what it's looking for. Because the value system that we're looking for, you know, the transformation of the bench has certainly been one of our successes. The report that the Chief Justice released today has all of the stats of that show the fantastic progress that's been made. Admittedly, not as much as I'd like to see on the gender front, but certainly on a race analysis, the judiciary looks completely differently, and that's really, really important, that when I go to court, the judge looks like me or shares some of my background and understands where I'm coming from. But in that JSC process, I think an articulation of what it is we want from our judges and how we can identify candidates that will live out and meet those expectations, rather than a tick box exercise of you know, race, gender, and potentially your background.
Michelle Roux, thanks very much indeed. Advocate, law lecturer, and co-author of the book Lawfare, Judging Politics in South Africa.